we're going to talk about the different ways that a gift can be made, and to get into that, we're first going to talk about the way that oil and gas interests are owned in Pennsylvania. And it's a brief overview of oil and gas law. Do you want me to stand up?
Yeah, you might want to.
Okay, sure. We're going to talk about the way oil and gas interests are owned in Pennsylvania. It's a brief overview of property law. So this is just a side view of a random piece of property in Pennsylvania. The house, of course, indicates the surface, and Pennsylvania courts recognize basically three interests in property in a general sense. You have the surface interest, and then below that are the structure and mineral interest, and those are two separate interests. The mineral interest can be divided among the coal interest and the oil and gas interest. We're here today talking about the oil and gas interest, of course. Along with the surface interest usually comes the air interest. But altogether we would have, all of those rights together would be what we would call the fee interest in the property. Now the individual that owns the oil and gas interest would have certain rights that come along with just those interests. And those rights can include just the right to search for and produce the oil and gas, the right to sell, lease, or convey the oil and gas, and the right to receive future payments. What's important is that the rights for each of these three property estates, the surface, the structure, and the minerals, they can all be sold or leased separately. And that becomes important when we talk about charitable gifts. That becomes important when we talk about liabilities that Tom asked about. So this is an example. We can separate all these rights as I just discussed, and we can convey them. And this shows how we can convey just a portion of the royalties from the owner to a charity. In another example, we can show how we can convey the exploration and the sale and the royalty stream to the charity, while the owner just keeps a portion of the royalty rights. So we're going to talk, Bob's going to talk about all the different ways that revenue can be generated by oil and gas production.
Good afternoon. My name is Bob Burnett. I'm an attorney in Pittsburgh, and I represent landowners throughout the United States, actually, in oil and gas matters. We don't have a lot of time here this afternoon, to discuss the intricacies of royalty ownership. We just want to give you a very high-altitude overview of what exactly is the interest that the charity would be receiving. When we talked about the interest, what is the income stream, or how do we monetize oil and gas rights? And there's really, for purposes of this afternoon, three types of interest that I want to briefly describe. So if you're having that discussion with a potential donor, that bell will go off and say, oh, I remember hearing about this. I think I understand where they're going. I think this can fit into our charitable mission. The first one is the very traditional and typical royalty interest. This is the royalty interest that we hear about when someone's talking about they sign an oil and gas lease, or hey, my grandfather has an oil and gas lease and he's getting a 16% royalty. That's the interest we're talking about. So we call it the traditional lessor royalty. And this is a royalty interest that is created and exists solely in connection with an oil and gas lease. You sign a lease, and it's one of the terms that you negotiate. In the Marcellus region, these royalties range between 12.5, which is the minimum royalty under Pennsylvania law, to about 18%. That's the landowner's share of production. If you imagine a pie representing 100% of the oil and gas revenues from the well itself, the owner, the lessee, the operator, is going to keep about 82%. 18% goes to the landowner. That's what we call the royalty interest. Now, one thing to keep in mind is the royalty interest created from a lease is not perpetual. It only remains in effect as long as the lease is in effect, as long as the wells that were drilled pursuant to that lease remain productive. If the lease goes away, so does the royalty interest. It is not perpetual. The other important component that we could talk about, again, an entire day, are post-production costs. Most royalty interests created under an oil and gas lease are subject now to post-production costs. So even though you negotiated 18% royalty, the operator is going to take deductions: transportation, gathering, compression, processing, costs that are incurred to make that gas, that raw gas, marketable. And as they move it downstream, that royalty interest is burdened by these post-production costs. So if there's a donation or an offer to donate a royalty interest under a lease of 18%, it may not actually be 18%. It's going to be 18% less the deductions. Another type of royalty interest that a charity may be opt to receive is a non-participating royalty interest. This is something that's created by virtue of a deed. It's not something that's in a lease. It is carved out of an interest in a deed. And we call it non-participating because the owner of a royalty interest doesn't have the right to negotiate an oil and gas lease. They simply have the right to receive income from hydrocarbon production from that particular parcel. This type of interest is perpetual. Now, there's some little nuances about whether it can be passed on by heirs. We won't get into that today. But for purposes of this discussion, a royalty interest created in a deed, a non-participating royalty interest, it is perpetual. And although it's sometimes subject to post-production costs, again, a different issue, the key here is if a charity is going to receive a non-participating royalty interest, this gift has a little more value in the sense that it's not going to go away. It's perpetual. It exists as long as the land is there. The final interest, and then I'll move along, is a overriding royalty interest. This is on the other side of the equation. You know how we talked about the 18% is the landowner interest and 82% is retained by the operator. An override comes out of that 82%. Now, it would not be uncommon for a charity to receive an offer of an override. That someone owns a 2% override in a particular leasehold or a 1% interest, that can be donated. Overrides are much less, and they are often, well, not often, they're not perpetual. They only remain in effect as long as that underlying lease remains in effect. So it's sort of like the landowner royalty, except it's coming out of the other side of the production. It's coming out of that 82%. It's called an override. There's a lot more issues here we could discuss. I'm going to turn it over to Betty. We can wrap this up. Thank you.
Thank you. Can you guys hear me all right? I guess as bad as everybody else. All right. I'm not an attorney. I am a geologist, but I have worked with attorneys. So we'll talk a little bit about structuring a gift. You're going to have a donor who's going to come to you and they say, I want to give you a gift of in-kind oil and gas rights. Well, they can come to you in several different ways. One, it may be a gift outright with warm hands. The guys are still alive. More often than not, it'll be a testamentary gift. And in that case, you may not even know you've gotten this gift until a landman comes to your door. And then the work begins. You may also have a funded life income arrangement, such as a charitable remainder trust or a charitable gift annuity. You may even have part of a retained life estate in which the subsurface owner has gifted those oil and gas rights to a person, and when they die, they then come to your institution, your nonprofit, your charity. And so those are the kinds of things, they come in all shapes and sizes. But I wanted to back up for a few minutes just to talk about a couple of differences. Oops, wrong way. You may have a donor come to you who wants to gift you an interest in a well. From a litigation standpoint, this is a gift you do not want to accept. These ones will have liability associated with well maintenance. You may have some kind of risk of litigation. You may actually have to pay things to keep the well going. So if a donor comes to you, wants to give you an interest in a well, politely decline and ask them if they have in-kind gifts of oil and gas rights or royalties. On the other hand, if they have in-kind gifts of oil and gas royalties, you have very low risk of litigation, you don't have to pay well maintenance, and as long as the well is producing, you'll receive some kind of income stream. Whoops. The two differences between an interest and a royalty is if the well isn't producing, you won't receive a revenue stream. The difference between the royalty interests, you may never receive one if the land isn't leased, but your nonprofit staff will have less work to do if you have a royalty interest. If you are given a mineral interest, an oil and gas mineral interest, your staff will have some tasks associated. You may have to negotiate a lease. You may need to contract experts to help you to get the best value out of this gift. So those are the main points that I wanted to bring up to this group this afternoon. And that's all I had.
All right, so if we've got charities in the room, and if they get to write the equation, so they're out and they've got Mr. and Mrs. Rights Holder, and they say, we want to make a gift, and we have 2 parcels of property. One of them has a traditional vertical oil and gas well on it, and they get $50 a month in royalties, classic held by production. The other one has no lease on it. And they say, we want to give 5% of our energy interests. And so you guys can tell them, and this person's very willing to do whatever is in the best interest of the charity for this future going forward, 5%. What's your recommendation on the way the gift should be structured to get the most economic benefit for the charity with the least work and risk?
Is it working? Yes. I think in that situation, that's the royalty interest or the mineral interest, where actually there is a deed from the individual to the charity conveying a 5% interest in the oil and gas estate.
So what if the guy says, but will you have to negotiate leases with my descendants in the future? I really don't want that. Then
Who's saying that? The donor?
the current landowner, the donor.
He doesn't want to negotiate leases. He just wants to.
No, so we've got the rights holders, and they say we want to give you 5%, but in the future we want to be able to control, the energy under our ground, but we want you to get 5%. So they say anything you want, but then they pull back a little bit when you start asking.
Again, I think the mineral interest, a 5% royalty interest in the underlying hydrocarbons is the way to go. That way, the donor is retaining the executive rights to negotiate leases. There's also retaining a 95% interest in the underlying hydrocarbons, but he's giving a gift, which is could be a substantial gift to the charity, which is a 5% interest, and that'll remain in perpetuity.
So for the charities in the room, you tell your donors you retain you call them the executive interest, which means they negotiate. The donor and or their family continue to control the oil, gas, mineral rights interest. They negotiate the leases, the bonus payments, etc. The charity gets the 5%. And from a liability perspective?
Yeah, from a liability perspective, the holder of the non-participating royalty interest, that would be the charity, has almost no liability exposure at all. They just simply own a a right to receive income from hydrocarbon production from that parcel. And there's really not much liability attached. Would you agree, Trent?
And so that works for land that's held by production and land that has no lease on it at all.
That's correct. The owner of the oil and gas rights, even if there's a lease in effect, they can still carve out their ownership interest in the underlying hydrocarbons. Now, it would be subject to the lease. In other words, in that example, the two parcels, if they conveyed a 5% interest in the oil and gas estate, the royalty interest, it would be treated a little bit differently with that lease, that parcel that's held by production, because it's a 5% interest in the royalty interest of that particular parcel.
Okay, so that's really, I think, what most charities, if I was running a charity, that's the gift I'm looking for. Now, as Betsy pointed out, there could be other things that are offered to you. It's important to understand what's being offered. You guys probably all have some litigation going on with regard to vertical wells that aren't producing, and there's debt and liability on them. So her point, Betsy's point earlier was, you might not, getting an interest in a well might sound really valuable, and it might just be a big pit hole for money in the end. So it's important to understand what you're getting. But generally speaking, the mineral interest, as described by Bob, is to me the best of both worlds. You get no liability, or almost no liability, and when the property's producing, you get cash. Remember the slide earlier, $50,000 a month. And those are turning out to be better than expected, but you get the royalty interest, and then you get the cash, and you don't have to worry about the liabilities. Any final comments? And all these panel members are available to answer questions if you guys now or at the cocktail hour, and I think their contact information is also available. Trent?
I would just add, if there is an active lease, the process is very simple. You can complete an assignment document, and to have the royalties assigned is very simple. Would you agree?
Yeah, it's relatively common. The E&P operators throughout the Marcellus region are very familiar with the concept of assigning a royalty interest under a lease. And also, if you acquire a mineral royalty interest, you also have to give notice to any leaseholder. And again, that's very common, and we do it all the time.
And we're going to be working together as a team on a simplified version of a document that you'd be able to use with the donor. We're going to share it with Bud and with everybody on the panel, so that hopefully it'll be something that can be user-friendly and won't require over-lawyering in order to get it taken care of, to make it hopefully a one-stop shop. Any questions for the panel members? All right, well, thank you guys very much.